Alrighty, so here we go. So we're gonna one more 30 seconds or so. We'll kind of wait for the clock to officially hit noon. We'll get started. Here we are. So welcome to our Lunch and Learn. This event is called Growing Pains, Intellectual Property, Strategies to Maximize Value and Protect Your Business. This is part of our Driving Business Values series from the ACG Programming Committee. My name is Steve Savoy. I'm president of Savoy Consulting. I'm also a member of ACG Detroit's Board of Directors, chair of our Diversity and Inclusion Committee, and part of the program committee. And thank you for joining us this afternoon. A few housekeeping tips for everyone. First of all, as webinar attendees, you will not have access to audio or video, but you will be able to hear and see everything our speakers discuss. You'll have access to the Q&A button and the chat boxes at the bottom of the screen. It's easier to use the Q&A button for questions because people can upvote your questions, but we will be checking both Q&A and chat boxes and answering questions at the end of our discussion. ACG's great programming is supported by many sponsors. We cannot thank them enough. ACG sponsors who have made this event possible are, at the gold level, JP Morgan Chase, Clark Hill, Cohen & Company, Comerica, Dauda Mann, Dykema, Huron, and Plant Moran. Our silver sponsors who are part of this and bring this programming to you are Amherst Partners, Bank of America, BDO USA, Butzel Long, Clayton McCurvey, Dixon Wright, Huntington Bank, Jaffe Raitt Hewer and Weiss, Pat Sangster, McDonald Hopkins, Purple Squirrel Advisors, Schaupitz, Madhaven, UHY, Williams, Ratner, and Plunkett. Once again, a great thank you for our sponsors. I'd like to introduce Justin Hanna. He's a corporate attorney with Jaffe Raitt Hewer and Weiss, and who will moderate our panel today and introduce the panel as well. Justin, over to you.
Thanks, Steve. Appreciate it. Good afternoon, everyone, and thank you for joining us. Today's panel is entitled Growing Pains, IP Strategies to Maximize Value and Protect Your Business. I'd like to take a moment to introduce the wonderful panel we have for today's program. First up is Jen Baird, who is founder, CEO, and director of Fifth Eye, Inc. Fifth Eye is improving the quality of care with real-time early warning systems of patient deterioration. Prior to Fifth Eye, as CEO, Ms. Baird led Axio Energy, is that pronounced properly? Focused on redefining the wind power industry with a revolutionary turbine-free aerovoltaic wind energy systems. From 2005 to 2010, Ms. Baird was co-founder, president, and CEO of Accuray Cytometers, a rapidly growing company developing and marketing breakthrough life science products for research and clinical use. Ms. Baird led the company to raise over $30 million in venture equity and debt funding, and in 2011, the company was successfully sold for $205 million, 10 times revenue, generating 5 to 6 times returns for its investors. Next up is Todd Dishman, who is Chief IP Counsel for Argo AI. Argo AI is a growing autonomous driving technology company. He is a registered patent attorney, having experience both in-house as well as in private practice. Prior to practicing law, Todd was a product engineer, taking a number of different products from concept to launch. He is also named as inventor on several patented inventions to which he contributed. His law practice has spanned from counseling Fortune 100 companies to sole proprietors and everything in between. This experience is what helped Todd counsel clients on IP matters with true insight into the what's, when's, and how's of developing IP assets. Next, we have Doug Lalone, who is a partner at Fishman Stewart IP. He is an engineer, patent attorney, and partner at the firm. He chairs the firm's strategic IP practice group, counseling portfolio companies, private equity, venture capital, investment banking firms on IP strategies, due diligence, and portfolio management. Doug works both on the buy and sell side of M&A transactions and has successfully prosecuted and defended numerous IP suits in federal and state and appeals courts. His cases have covered patent, trademark, trade secret, unfair competition, domain name, non-compete, and copyright infringement claims. He has also prosecuted hundreds of patent applications on consumer industrial products for middle market companies and routinely conducts brand clearances and trademark applications to help clients protect their IP positions. Finally, our panelist, Skip Sims, who is Senior Vice President and Administrator for Ann Arbor Spark and the Michigan Angel Fund. As Senior VP of Ann Arbor Spark, Skip works with technology startup and early stage companies. His focus on preparing startups for equity is for preparing startups for equity fundraising. He is a managing member of the for-profit Michigan Angel Fund, which invests in Michigan-based technology companies that are capital efficient. The Michigan Angel Fund is the state's largest angel group with 140 high net worth individuals looking for above average return while helping grow and diversify the state's economy. Skip has been successful in raising over $26 million in grants through the state's 21st Century Jobs Fund program for the Michigan Pre-Seed Capital Fund. This program provided very early stage startups with small loans and matching investments of up to $250,000. Myself, I am a corporate attorney at Jaffe Raitt Huron Weiss. I'll be your moderator today. The focus of my practice is in mergers and acquisitions, and I've advised clients on transactions from $1 million to over $1 billion in aggregate consideration. As a part of my corporate law role at Jaffe, I act as outside general counsel to several middle market privately held and platform companies. And in that role, I regularly advise on a range of issues, including IP and brand strategy. To learn more about our panelists, there is a link in your webinar chat that you can go to that has more in-depth bios. So obviously, each of our panelists have been recognized for their achievements and their work, and we look forward to a thoughtful discussion today and maybe a reprieve from some of the election coverage on how to efficiently utilize, protect, and plan around your intellectual property to help navigate the path of business growth. Having a strong intellectual property strategy is a crucial step in preparing for the future when scaling a business. We are going to explore the best practices for implementing an effective IP strategy and common pitfalls to avoid from the perspective of our panelists who advise, lead, and invest in startups, early stage, and emerging growth companies. So, first and foremost, why don't we discuss, what really is an IP strategy and why is it important? Maybe Doug, you might have some input on this one.
Yeah, and Justin, thanks very much. I appreciate the opportunity to be here with the group today. And no politics. We're not talking about any elections. We're going to talk about IP today and how to build businesses and make them strong. So thank you for this opportunity, ACG and Justin. So I think I want to just kind of point out an IP strategy is a thought pattern that an organization hopefully addresses up front to figure out what their end game is. What are they trying to accomplish at the end of the day? So there are really kind of two strategies to this, or there are lots of strategies, but I want to share with you two concepts. One is a defensive strategy, and one is an offensive strategy. So when a company is thinking about building out an IP program, you need to really think about what is my exit plan going to be, and what's the end game. That's particularly relevant for Todd with his company, and Jen with her company, and the company Skip invests in, to figure out what is the end game. So here are two thoughts. A defensive patent strategy is when you're basically building a moat around your business model, your business plan, to protect the innovations, to protect the market share, and to protect the revenue stream. And when you do that, you are hopefully increasing the value of the company. So it's a defensive strategy where you're building a moat around the business, all right? Now, an offensive strategy could be looked at a little differently, and that is building an IP strategy because you want to use the IP assets to help as part of a business plan. That is through maybe licensing the technology, or perhaps you're going to take a book of patents or trademarks to market, and maybe you're going to leverage them through a series of lawsuits. So offensive is more building with the thought of leveraging it to generate a revenue stream. And one thing that we didn't really mention too much in our rehearsal session that is, there are firms out there that are taking these patent portfolios and they're leveraging them, and there's now litigation funding. In fact, in the third quarter this past year, litigation funding for patent or litigation suits in the United States are up 36%. So there's a huge influx, even during COVID, for people taking patent portfolios and taking them to market and suing different entities. So that's an offensive, that's a powerful strategy that a company could deploy to try to build out and generate revenue.
Very useful. I mean, maybe Todd, maybe you can talk a little bit about how relationships might affect that strategy that Doug mentioned.
Sure. Within the offensive filing framework, there's other considerations to be had, particularly in a commercial sense, in that your relationships with your business partners, your suppliers, your customers can all come into play as well. I've seen it happen both under good context as well as bad when it wasn't foreseen in advance, to the extent that you develop IP with suppliers, establishing who owns the IP, who files on what, gives you the leverage to be able to make better commercial decisions, to move business more freely, as compared to if the supplier secures the IP, then they can also supply to other customers besides yourself. So going both upstream and downstream, the commercial relationships can play into your IP strategy and where you choose to file and what you choose to protect for your company going forward.
That makes sense. And, I know, Doug, you provided us with a slide earlier. Why don't I put up that slide? Let me share my screen. And Doug, if you could give us a quick primer on the various intellectual property types that we're actually talking about here.
Yeah,
Give me one
actually,
moment.
that'd be a great idea, Justin. Thanks for sharing that slide there. Traditionally, we think of intellectual property falling into four different buckets. You think of patents, trademarks, copyrights, and trade secrets. In the venture capital space, or even in straight up private equity space, where you have more mature companies, they're all equally important. And it's important to think about what is your end game, what is your exit strategy. So this little visual here, we show on the top left corner, the first bucket is patents. There's a picture of a gas turbine engine by Rolls-Royce. And a patent by definition is basically an intellectual property tool that gives you the right to exclude others from making, using, and selling the invention for a period of 20 years now. Now, there are lots of different patents. There are utility patents, there are design patents. There are even patents on plant seeds. So Monsanto has patents on corn, the type of corn that they may genetically engineer. So within the patent bucket, there are different types of patents you can secure. Moving to the trademark bucket, I put my favorite emblem there, Harley. I like to ride Harleys. I have a Harley Softail, as some of you may know. So I love Harleys. I love the sound. Did you know the sound can be patented? Trademark, excuse me. Did you know this logo here is trademarked? Of course, the name itself, Harley Davidson itself, is trademark. So trademark by definition is a intellectual property sign, designation, or expression that identifies the products or services of an entity, okay? For example, when you hear Shell Oil, you think, oh, it's that gas station company that provides gas station or provides gas services, things like that. So trademarks are often a very powerful tool that people protect. Copyrights, that's our third bucket down here in the bottom corner. What I showed a picture of here is computer code. And that is really big now with everything that's going on, even in the AI space with Todd's business, or in the healthcare space that Jen is operating in. Computer software and software as a service is huge. We know how they performed and been important during the COVID crisis. So computers, software are all protected by this thing called copyrights. And that's basically a work that's fixed in a tangible medium. That could include literary work, pictures, artistic work, music, etc. So copyrights cover a big bucket. And then finally, quickly, trade secrets. The most favorite trade secret or famous one you may think of is the Coca-Cola formula. That formula is not known. It's been kept secret. And it's highly valuable to the Coca-Cola company, probably the most valuable asset they may have, they may argue. The definition of a trade secret is an IP asset that could be formulas, practices, processes, designs, instruments, things of that nature. So it's a big category of things. And often you hear the term know-how that falls under the trade secret status. And some of the important know-how or trade secrets a company may have could be business information, customer lists, pricing schedules, formulas for a paint company, things like that. So that roughly is a primer of the IP bucket that we will be hearing more about here today with our other speakers.
Thanks, Doug. That's very appreciated. So I guess one sort of initial threshold question that a business might have is whether or not to patent, right? So making the choice to affirmatively patent something. Jen, can you talk about why or why not a company might make that decision?
Yeah, that's great examples, Doug, that you gave about what are some of the different types of IP. And oftentimes you're making a choice between whether you want to keep something as a trade secret or actually go through patenting it. One of the aspects, there's a number of different topics that you can think about, and it depends on what kind of company you're running and what the long-term game is, which we talked about earlier on the panel. I generally lead venture-backed companies, which means that the plan is to sell the company at some point in the future. One of the biggest things that you sell as a venture-backed company is your intellectual property. And so there's a push towards trying to patent things because it gives you something, it gives you some intellectual property assets to actually sell. However, by patenting, you must disclose what is the invention. And you have to disclose it so somebody skilled in the art could actually make and use that invention. And so by doing that, you're actually giving your competitors an opportunity to see how you did what you did and to try and design around that. So one of the big things to think about, and I've done this I've had patents in every one of the companies that I have led, and I've also had trade secrets in every one of the companies that I've led. And there's a tug of war, how do you want to decide which things to patent and which things not to. So some of the little rules of thumb that I often use are, if I'm thinking about patenting something, if the thing is something that's easily measured by my competitors, meaning they get their hands on one of my products and they can measure it. So oftentimes this would be a mechanical design. They can actually see and measure it. They can actually get the measurements and probably figure out what the design was. And therefore patenting can be very valuable because that gives me the right to say, no, you can't use that design. On the other hand, if I've got something that is very valuable, but I can make it very secret, kind of like your Cokes thing, only in my case, it's usually some encrypted little bit of software that can fit on a chip somewhere, and that somebody can't get access to, then I might keep it as a trade secret because I don't actually want people to know how we got, for example, at Accuracy Cytometers, 6 decades of dynamic range out of a PMT. We did that with actually some very sophisticated software that was encrypted on a chip that nobody could reverse engineer. Literally yesterday, I had a conversation with one of the biggest multinational companies in the world. And one of the things we were talking about is the software that our software as a medical device at Fifth Eye runs on. And the discussion was, right now, we've made the decision to keep that. We have 2 patents on it, 2 patents on the methods. But we actually haven't published our software. And we're keeping a lot of the techniques by which the software operates on streaming data a trade secret. And how are we doing that? Well, we're actually keeping it in AWS's cloud where we can actually keep tight control over it. They were asking the question, could you put that software onto all the monitors all over the world? And I'm like, I don't really want to do that because that actually exposes the software to somebody hacking it and getting their hands on it. And since we do plan to sell ultimately in China and places that have less respect for intellectual property, I don't want to take that risk. So these kinds of risk and how easy is it for somebody to reverse engineer and how costly is it, and what you're protecting and what you're trying to do with it all kind of factor into this question. One factor that you do have to keep in mind is I kind of have a rule of thumb for myself. The patent attorneys on this may want to refine that, but if I'm thinking about patenting and I'm going to go international with it, it's a $50,000 question by the time all is said and done, at least. You know, it's not $10,000. It's not the first drop in the bucket. By the time I'm done, I'm going to spend $50,000 or even $100,000 on actually protecting that patent. So you want to be selective about it. You don't patent everything under the sun because it's just too costly. And especially if you want to get international protection, the costs go up pretty dramatically from there. So you want to be selective about what you patent, and you want to make sure you're patenting the most important things, and you want to make sure they're actually things that somebody competing with you could get access to by looking at your product, rather than, you know, nobody knows how to make Coca-Cola and what the secret formula is. And if you can keep it a secret, that can be very powerful, although it is potentially hard to sell and not necessarily easy to value in an acquisition.
I'd like to chime in just very quickly. I think Jen hit the nail on the head, very, very frankly, but for Argo in particular, it's particularly difficult. And this is a question I have to answer on a daily basis and explain to technical leadership and, you know, what the considerations are. Argo, and it's unique because we are a software-based company. So all of the concerns Jen mentioned are in play, but also it's a new industry. It's an emerging industry. So we're trying to forecast what's going to be in play 5 and 10 years out, and then make that decision today, whether we publicly, you know, go the patent route and publicize what we do, or vice versa, choose to keep it behind closed doors, and then manage the secret on an ongoing basis, which also takes a lot of effort. So I think she hit the nail on the head, like I said before, but what particular industry you're in and the types of products and services you offer can certainly also make the decision much more difficult.
Absolutely.
Yeah, can I
Yeah,
just
that
say-
makes.
Okay. Well, I have one
Sure.
follow-up point on Jen's concept on software. There's actually a tool available through the U.S. Copyright Office that would allow companies to file a copyright application on their computer code, mask out a large portion of the computer code, and then that way you can get the copyright registered for the code, but you're still keeping the code a trade secret. So then you get the best of both worlds. So that is an available tool. And that way you're not doing, like Jen said, if you file a patent application, you're disclosing it to the world. So you just waived your trade secret. So 2 of the 4 buckets you can get for copyright for software by filing copyright application, but still keeping the code a trade secret. So that checks 2 boxes for those who want to keep the IP game at high stakes in that regard for code.
Yeah, it's a great idea.
Makes a lot of sense. And, you know, Jen, you had mentioned something about the cost of filing for some of these protections. Can you tell us a little bit more about like the cost benefit analysis that goes into making those decisions?
Yeah. One of the things that I think when I first started working with patents, and that was like 20 years ago, I didn't understand all the layers of cost, because you'll often look at it and say, okay, I'm going to file a patent. I need filing costs with the USPTO and possibly international agencies, as well as the attorney's fees to actually write up the patent. And definitely, I believe quite strongly that you should be using an attorney if you're writing a patent. There is a lot of art to writing patents in a way that the patent office is going to accept. And while theoretically you can have your engineers write a patent application, that's usually not their area of expertise. And the whole language that's used in patent land is arcane, to say the least. So I don't think it's a good idea to file patents without an attorney's help, and that's costly as well. What I found is, you can file an initial provisional application, and then you go to a full application, and then you'll have costs that are aligned with responding to the USPTO's response. And so you have to, and it's very rare to actually file a patent and have it just go through. I mean, that is exceptional. You can expect that you will get a response and they will reject all your claims, and then you have to argue why they are valid, and then hopefully most of them come back. But the expectation that you would just file a patent and it would just go through is not reasonable. And then from there, if you're filing internationally, there are some harmonization techniques that allow you to file with one fee across a bunch of countries. And then there's the stage where you have to go national, and now you have to decide which specific countries am I going to go into? And each country has its own fee schedule. And so this is how these numbers that might sound like, oh, it's only going to be a few $1,000s to file a patent. And that's true at the beginning. The problem is once you start down that road, unless you keep paying money and there's maintenance fees on top of this, you don't get to keep the patent. So don't start if you're not ready to finish, is my word to the wise. Like, don't start down the path and not get all the way down. And there are some really creative techniques that I've used where you actually paid more money, but we got patent decisions much faster. In particular, I mentioned I have a software company with 2 patents, and they're patents, they're not copyrights. And so, how did we do that? And one of the things that we actually did is we used a series of techniques together to actually make sure that we got an answer from the U.S. Patent Office before our intellectual property was published. So that's another thing to keep in mind is oftentimes you file a patent and the patent office will publish your secrets before they tell you if they're going to grant you a patent. And so you have to be smart about whether you're prepared for that. In our case, we weren't prepared for that. We were not willing to let the patent office publish before we got the grant. So we came up with a patent strategy that allowed us to get ensure that we got a decision, or at least had the opportunity to withdraw the patent before it was published. So those kinds of questions about letting your secret out and whether that is devastating or not has a lot to do with what other intellectual property you have around it, what other patents you have around it, building up a patent portfolio. At Accuray, we had 25 patents by the time we were sold. And that was something that was very valuable to the acquiring company because it allowed them to defend us. That's the other thing about costs is, in theory, hopefully, we talked about offensive patent strategies. Somebody could come after you and decide they were going to sue you, and then you have to defend that patent. And that just adds layers upon layers upon layers of costs. I haven't actually, I've gone through the process of invalidating other people's patents, but I actually haven't had to defend a patent yet. But oftentimes the big companies, the Becton Dickinsons, the Philips, the Siemens, the GEs, the big companies out there are used to, and they have whole teams that do this. And so when they buy a patent portfolio, and this is big tech companies are the same way, they actually have the resources to defend. Little companies like mine would have a really hard time defending just because of the cost. But that doesn't mean that our future acquirers don't have an interest in defending a patent position. Not sure if that hit all the points you were thinking about, Justin, but a few more thoughts on cost.
No, I think you got it. And I know, Skip, you had some examples in your experience with the Michigan Angel Fund and dealing with, other companies out there of exactly what Jen's talking about.
It was, we've got both an offensive and defensive story. We didn't invest in one of the companies in another company, Spark did back in 2007. And this was a company that had created a very creative, unique way to apply safety devices to firearms. And it was unique. They filed the patent, they had the patent, but then they got notified to cease and desist by a large gun manufacturing company. And despite whether or not they had infringed on that gun company's patent or not was irrelevant. The bottom line was what Jen just pointed out. Now, this poor startup that had just raised probably less than $1 million has to defend that. Well, there was no way they were going to defend it. And they weren't going to take, and to the CEO's credit, the founder's credit, he wasn't going to take the investors' money, which was put in to develop the product and go to market, and use that capital instead to defend a patent, which could drag out for years. Mm-hmm. This is not going to be settled in 90 days. Yeah. And to his credit, he notified us right away and he said, look, I know it's a losing battle. I'm going to shut down the company, and gave us our money back. We had another company that was on the other side where I felt like they had wasted money on patents. It was a concrete company. The concrete company did a lot of design. They did a lot of fancy patios, outdoor kitchens, a lot of different things you can do in a stylistic kind of way with concrete. And he had a national distribution model. And so he felt like he needed to patent all of his various designs, et cetera, et cetera. And he had a bunch. I don't know how much he had spent on patents, but he had several. What he found, though, as he was going around the country and selling his designs in specific markets, he found that the majority of his competition was really mom and pops. He was not really competing with another national firm. He was competing with a local concrete company that was basically trampling all over his patents with designs. Maybe they weren't exactly like his, but they were close enough. But he was looking at this and saying, wait a minute, it's going to cost me more than the patent did to go after this poor mom and pop. And he was finding it in markets all over the country. So he'd have to do this like 100 times. And that was just kind of a, I said, well, and he was, and the reason it even came up was he was considering issuing or trying to get more patents. Wait a minute, time out. Why are you spending all this money on something you can't really defend and that nobody's going to, nothing really you can do about it. So
yeah, that's a great example of how you have to understand what patents give you, which is the right to sue somebody. And if you're not prepared to do it, don't go there.
Right.
Yeah, and if I can follow up on that same point, that firearm company in Skip's situation, they received a patent, and that patent in itself gives that company the right to exclude others from making, using, and selling the invention. Getting a patent does not give you a right to actually make your thing, your widget, and not get sued. So keep in mind, a patent does not mean I'm free to operate and sell.
Correct.
Patent just means you can exclude others from making, using, and selling in the United States the patented thing. So if that firearm company wanted a clearance investigation or what have you to make sure that they're not suing the big company's patent, so they're not infringing the big company's patents, what they could have done in that situation is conducted a freedom to operate investigation to see if the landscape was clear of any landmines. And if so, then the investors in that situation maybe could have proceeded forward with a clear thought pattern thinking, okay, I'm not risking my investor dollars by investing in a company that may be an infringing company, even though they have their own patent. So that's often a misunderstanding with people getting a patent. They think, I get a patent, I'm free to sell this. No, it's not a clearance to sell. So that's all obviously often a misconception.
Yeah, Doug, I used to highly recommend, doing a freedom to operate search first. I'm not as strong about pushing it, but I know a lot of other people consider that aspect a waste of money also.
Well, and it is, right? It is the problem with freedom to operate is you have to look very specifically at claims. And this is extremely challenging to do broadly. And so this is a point of contention when you're raising money, because you'll have people say, have you ever done a freedom to operate? And I actually do a lot of informal, not using attorneys, freedom to operate with my engineers. But it's actually quite expensive. And oftentimes what you get from a freedom to operate is extremely narrow. But you should have the people who are designing your product be aware of the space. And you need to know how crowded the space is. I did, when I was developing flow cytometers, there was like nobody, I mean, there were so many patents on flow cytometers. And, it was quite challenging to figure out, okay, where are the limits? Where do we have to make sure our design lives? And we actually had to, we had one patent that one of our competitors had that was actually, we were infringing on. And we didn't know a way around it. And so we pursued this, and then we discovered, this is really a crazy story. We discovered that there was a analysis done by the company that owned the patent that actually resulted in, we found some prior art. So basically somebody else had invented this thing that they had patented. We found some prior art. And so we actually wrote up an argument for any time if somebody tried to enforce that patent against us. We had basically a suit ready to go in and invalidate that patent. We found prior art. And then it was like a year later, and we went looking for that patent as part of a fundraising thing. We discovered that they had actually accidentally, maybe on purpose, invalidated their own patent, which was bizarre. But it was like, okay, anyway, that patent disappeared off of our radar screen. But it's this whole question of what rights does it give you? You do have the ability to go argue against the validity of a patent by discovering prior art that's valid for that purpose. And we actually done that. Like I said, we had the lawyers we had litigation attorneys that had prepared the entire argument. It was on the shelf, ready to go the minute this thing became a problem. And then we discovered that they actually invalidated their own patent. I'm still never quite understood or learned why they did that. And maybe they did it by, maybe they did it while trying to do something else. But that's actually what happened. This whole question of being able to protect it, not protect it, those kinds of things is super important when you're thinking about intellectual property, how it fits into your business strategy, when you can use it, how you're actually going to use it. Like I said, if you don't have resources to enforce these things, you may be far better off keeping it as a trade secret, or trying to outdesign someone else. You should be very, very aware if you are going into a space that is crowded. I think this may be true of Argo, I don't know for sure, but it's certainly true for Fifth Eye. The space that we're in is super, there's not a lot already patented. And so that gave us an opportunity to get patents very quickly. We actually got, for my wind energy company, a patent that got, believe it or not, actually got through without being rejected. And it was literally using a process very generically defined 10 feet off the ground, patented. We were blown away. We couldn't believe that the patent office gave us that. It was because there was nothing in our space. And as a result, we got extremely broad claims because it was one of these things where it was a physics process that we patented, that we learned and was novel, and we understood it and were able to articulate it. Operated anytime it was 10 feet off the ground, that physics process was operating, we got a patent on, which was crazy. I've never seen anything like it. It was very much a lark that we filed it, because we were like, they're never going to give us this. And then they gave it to us with like not even arguing. And you're like, this is crazy. So I've seen things go like the full spectrum. And this is where you really want to have a good relationship with smart patent attorneys that can help you understand the space and understand what your strategy options are. I don't think it's a good idea to try and figure this out as the CEO by yourself, because there's too many nuances, and it's a very specialized area, and you want to have very good advisors on it that are thinking strategically about what it means, and then you want to listen to them.
Yeah, and I think I'd like to touch very quickly on how maybe an exit strategy, or how the exit strategy might affect whether or not to file for IP protections, and how intellectual property might actually affect valuation of a company. I don't know, Skip, do you have some insight there?
Whenever an investor is meeting with an entrepreneur, even for the first time, just to kind of get acquainted with the entrepreneur and the product or service that they're trying to raise capital for, there's a short list of questions you ask in that very first meeting, and one of them is, what IP do you have? It doesn't have to be a patent, but we want to know, okay, if you're going to scale this company and you're going to disrupt the world, you better have a strategy, and I assume you've got some really special sauce, and how are you protecting it? So that's always a question up front. The entrepreneur needs to be prepared to answer it. It goes to Doug's initial point. What's your strategy? And it may not include a patent. It might be the other things, trademarks, or one of the other items, but you got to have that strategy, because the other thing then that we may not be telling you at the first meeting, but it's certainly going to be part of our diligence, and that is, what is the exit strategy? And what kind of IP protection needs to be created before we get to that point, because the acquirer is going to do a whole lot deeper dive than we ever did in terms of that IP and how good it is and if it has value. Is the IP at the end of the day what you're selling? Sometimes, companies acquire companies for the IP. They don't care about your business. They don't care about the customers that you've got. They don't care about your revenue. They want that secret sauce. That's what you're selling. Do you know that up front? And if so, be hell bent on making sure you've got it. If it's the business model and all you're really doing is kind of protecting it and the trade secret will work just fine, great. We're not against that. We're not saying you shouldn't, but know what the end game is and work backwards. That's the way the investor's going to look at it. I'm looking at the end game. Where are you 5 years from now, 7 years from now, 10 years from now, when GE buys this company or Becton Dickinson or pick a company? And what are they going to be looking for relative to the part of the market that you are disrupting and interrupting their sales flow that makes them want to acquire you? And so your IP is a critical element of that, but be thinking that far ahead in advance and then work backwards on how you're going to get there. I think one of the points made earlier also was having enough. I mean, depending on the industry that you're in, we did invest in a company that we thought, when at the time we invested, 5 patents, we thought looked pretty comprehensive, covered the technology for the most part. It was in the lighting industry. I'll tell you right now, if you're in the lighting industry, that is one competitive industry and business. And finally, we got a CEO from the lighting industry from a big company who was helping us try and get to, okay, let's put some value. Let's see if we can exit the company sooner than we had anticipated. He said 5 patents is nothing. In the lighting industry, for Philips or anybody else to want to buy this company, you're going to need 30 patents. You're going to need at least that many patents to make sure that what you've got is truly protected. And that was a shocker to us. So lesson learned in that regard.
Yeah, and it would certainly be expensive to invest in 30 patents, I'm guessing.
Yep.
So I'd like to take a moment before I move on to my next question, because we're running a little short on time, to encourage any questions that some of our audience members may have, using our Q&A function to submit your questions through there, and we'll try to get to them after 12:45. So I'm going to skip ahead, and to the extent we have some more time, we can work back to some of the other questions. Let's talk big picture here and sort of the topic at hand. Does intellectual property actually create value, and how? I'll allow the whole panel to weigh in here, but Skip, I think this was sort of ancillary to the point you just made.
Yeah, it does create value because if you've got some investors, the VC world, the angel world, private equity, but VCs in particular and the angels are looking for companies that truly are disrupting the status quo, that are truly creating something brand new. They're changing the world, at least in that industry. That's what we're looking for, because that's the value. Value can be, determined from a lot of different aspects. It might purely just be your business model. It may not have anything to do with the product and technology per se, but your business model and strategy. But IP definitely, and knowing that at minimum, you've got your, you've got your IP at least protected to some degree. It definitely adds value. But again, depending on the industry, life sciences, healthcare, pharmaceutical, or an app, depending on the industry, kind of drives the degree of value that that IP provides. So again, know your industry. And, you know, one of the things we look at going in is the entrepreneur and how much experience does that person have or the team have in that industry, because all the industries have their own little nuances that you just need to be aware of.
Right.
I'll chime in really quick. To Skip's point, I agree that it matters very much to investors. Obviously, Argo is a startup company, so what the street thinks of us is important to us, as you can imagine. But in addition to that, partnerships, to the extent that we're viewed as a technological innovator and it's documented as such, it encourages other companies to partner with us for other research projects, endeavors, and other, just to further the technology and move the industry forward as a whole. So not just investors, but also partnerships, being viewed as a technological innovator, recruiting. Recruiting is highly competitive in this industry. So to the extent that we are, once again, viewed as a technological innovator, we get top-notch recruits from the best of the best research institutions that, oh, by the way, we may partner with in addition to. So we believe our IP creates value in a number of different ways. First and foremost, like Skip said, the investors, but beyond that, there are a lot of other soft benefits to us publicly innovating the way we do.
Great. So we actually have unless any of the other panelists have something to weigh in, we have a question from an audience member. Alex Drost asks, how do you recommend balancing between cost and protection? And, you know, he understands that there's no clear rules, but what's the framework that you might use?
I can speak to that. One thing there's several factors. One factor that we haven't actually talked about that much today that I want to make sure we call out is actually how fast is the innovation happening in your company. It takes a while to actually get a patent issued. Think in terms of years, and then you get a 20-year protection to it. So actually, you have to think about how fast and how solid is the innovation that we're using. I will use an example of, we filed a patent on something we called the squid. Doesn't even matter what it was. This was for a flow cytometer. It was a solution that we had at one point. And it actually, a year later, by the time we were filing a full patent, we had innovated past the squid, and the squid no longer mattered, and we abandoned that patent. And in the software space, you know, we talked a little bit earlier about actually filing copyright on software. Well, one of the things about software is it keeps evolving really fast. That the way you actually do innovations in software is often by basically improving upon your software routinely. And that's actually one of the challenges that I face right now is my software development team is making our software better every week. And so by the time, you know, I have to be really strategic about what I'm going to patent because it needs to be durable. It needs to be something that's going to be around for, let's like imagine 10 years. If my software is changing the aspect that we're talking about, I'm not going to invest in a patent because by the time that patent is issued, it's not going to be valuable to me anymore. So to give as an example, Fifth Eye is commercializing an analytic, and it's based on a specific model. It's based on some very specific techniques. This model was built 4 years ago, and it has not changed, and it's not going to change. So that means it's worth patenting some of the pieces that make that unique because I have a durable competitive advantage. When I was building a flow cytometer, the flow cytometers we designed are still being marketed globally. $1 billion market now. This is 15 years after we filed the initial patents. Okay, that IP makes a lot of sense. So some of it is how fast is the innovation happening? If you're not talking about the kernel of the innovation that's going to persist for, think, decades, it's probably not worth patenting. It's probably worth more keeping that a secret. So one of the big factors in deciding about that is assessing where your technology is. Another thing is, what markets are you going after? We talked earlier about an example of somebody that's, you know, competing against mom and pop's design for landscaping. Well, okay, that intellectual property doesn't have broad applicability. You know, I'm looking at something where I'm looking at now pursuing an international, both regulatory and patent strategy, because I'm going to sell this technology that can be used all the way around the world. If I've got something where I have a global market for the same thing against competitors that you can push away against other global competitors, that's a factor that goes into it. The whole question of whether you can actually really protect the secret is another factor, because if you can't protect it and you have a global market and it's going to be persistent, now I'm leaning toward patents. If it's something that is going to change fast, that is only going to be in point markets against competitors that I can't realistically push out with patents, then I'm going to be leaning, and something that I actually can protect. Now I'm leaning more towards something that is a trade secret. And that's a business strategy question, is to what's the value of the intellectual property? How are you actually going to monetize that value? Who are you competing against? All those factors come into play as to whether it's worth spending tens of thousands of dollars to protect something, and whether you can actually use that intellectual property to protect it. As a startup company, I'm probably not going to be out there enforcing my patents, but I sure as heck, in the 5 to 7 year time frame that my company will, before it gets acquired, be building up an intellectual property portfolio that my acquirer can enforce, and that increases their interest. I mean, I was having a conversation earlier this week with a future potential acquirer of Fifth Eye. They asked me, what are your claims on your patents? You know, what are you covering? And because that's one of the first questions, you know, what they're interested in, that kernel of IP, because for them, that's a strategic advantage in a way that for a little company like me that's only got a few $1 million is a different thing than when they're competing with other global titans.
Go ahead, Doug.
Yeah, Justin, just to follow up on Jen's point there. So if you look at the value of IP, and I think your basic question was, does IP really create value? So in Jen's situation, I'm just making up numbers. I don't know what her revenues are, but let's say she has a book of patents, and let's say that book of patents covers $20 million in their revenue stream. But the acquisition company has a bigger eye for this. They can see, hey, these book of patents will cover, let's say, $1 billion industry. They actually they can evaluate, and that it can cover this part of the market segment, even though Jen's company is just a small piece of that pie right now because they're a startup. So the value of the IP in that case would be run by the finance people, and you would ask the question, if I can own a $1 billion market piece, what would be the price of that? What would be the value of that? It's not the $20 million revenue stream Jen has, but it's the value of the monopoly of protecting entire marketplace, which is what the patent does. It excludes others from making, using, selling that invention in that $1 billion marketplace. Now we're talking about some big multiples when you look at it that way. That's where the value is in this particular situation, hopefully for Jen.
Yeah.
All right. I'd like to use maybe the next 7 or so minutes that we have on this program to maybe take a step back and start thinking about, you know, what are the actions that one might want to take when launching a business or product. You know, I got a question in asking, you know, as an entrepreneur, where does the IP come into play? Do they need it before they have customers? You know, can you start in the US and then expand? One of the other things that we discussed was, you know, freedom to operate investigations. Can whoever wants to take the question maybe chime in on some of those points?
Maybe rephrase that, Justin?
Sure, yeah, sorry. So
The
first
questions
question
embedded in
is,
there.
yeah, sorry. So the first question is, as an entrepreneur, where does IP come into play? Do they need it, you know, before they have customers?
Yes.
Or is it something that they should get into maybe after they have some revenue?
So this is important. If your IP is on your product and if you've publicly disclosed your IP, meaning you've shipped your product to your customer, you can't protect it anymore. So you need to actually file patents while you still have it, while it's still a secret. And one of the criteria of whether something is patentable is to whether this secret has been published. So the time to file patents is actually before you publish on your invention. This can be a real tough thing when you're talking to research universities and people that are really into publishing, because sometimes they will have invalidated your IP rights inadvertently. So you'll need to figure that out. But if you are shipping a product that embodies your IP, and that IP is visible in the product, you're already past the point of it being a secret. So it's publicly disclosed. So one of the things you have to worry about is public disclosure of your IP. Can't happen before you file for your patent. So these are the timing. Generally speaking, you're going to file patents around a product, and you need to be filing those when you're actually doing the invention of the product and the development of the product, not once you're commercially shipping the product. A different type of IP, so trademarks, actually you can file for a trademark, but you actually have to start using that trademark commercially, meaning you have to actually be selling something under that. So for example, at Fifth Eye, I have two trademarks. I have a trademark on Fifth Eye, and I have a trademark on Beyond Vital Signs. And in both cases, because we're an FDA regulated product, we need FDA clearance before we can start selling, which we hope to get in the next month or two. But I keep having to file extensions on my trademarks because I can't actually demonstrate that I'm using them in commercial use because I'm not selling anything yet. So I wanted to have these things trademarked. So I've paid for a trademark application, and then I keep extending it by 6 months until I can demonstrate that it's in commercial use. So depends on the type of intellectual property as to where the timing gets. This is why you need your favorite neighborhood intellectual property attorney to help you figure out the exact timing rules that apply in your situation and for what you're trying to do. But timing is super important because you can, there are windows of time that you can formalize these intellectual property pieces, and it differs based on what it is.
And I think that, part of what you said is important because if you're, trademarking a name, for instance, maybe that name is already being used or there's likelihood for confusion, and, you might have to go in and change your name. So you'd want to do that, obviously, at the front end of operating your business, as opposed to making investments into those names and then having to change it.
It's a great example, Justin. Actually, Fifth Eye started out as the company name was Trove Analytics when we rolled it out of the university. And I looked around and just Googled Trove, and there were a bazillion Troves. And I got really uncomfortable. I thought, we're going to have a hard time trademarking this name. And so I made a couple of decisions. I raised money, but I never built a website. I never did anything to invest in that name because I was pretty darn confident that we were not going to be able to trademark it and we were going to want to. And so I raised money and didn't invest in any kind of, equity into that name. And then we went through a process once we had funding with a designer and marketing person to actually come up with a new name, new logo. And we picked Fifth Eye because we could trademark it and because it was memorable and because it fit all these things. And then after we did that, we actually built the website. We just went through and legally changed the name of the company to align with that. But it was very specific as we had a working name. It became apparent that it was going to be hard to protect, and we decided specifically not to invest in it until we had the funds to actually rename the company and then invest in building a brand around that.
Makes sense.
So those are really important conversations and discussions to have. You just don't pick a name. Like, people are always picking names like, I this or I that. Trust me, Apple's got this world covered. You do not want to go up against Apple's marketing machine or their intellectual property protection machine and try and leverage the equity they've built in the I whatever. And so these kinds of things are really important because you can end up, if you're sued as a startup company for intellectual property infringement of whatever type, it can be the death knell of the company, not because you don't have great stuff or great idea, but because you can't afford to solve it and you can't raise money when you're under that kind of a cloud. And so these kinds of things, you have to just be thoughtful and careful and decide, does anybody care? Is it worth it? Is it worth protecting? Is it not worth protecting? I think those are such important strategic questions to ask yourself as a business leader.
Makes sense. And I think I want to spend maybe the last, 30 seconds of this conversation highlighting a couple of points that we didn't have a chance to get to on this webinar. One is, your employees and consultants that you have working for you, things for people to be thinking about, right? You want to make sure that your agreements with your employees and your consultants have the appropriate language, IP assignment, and ownership of works that get created under their employment or their consulting relationship, independent contractor relationship with you. So you want to make sure that you have the right agreements and the right language in place. And the last thing, and probably most importantly, is making sure that you're finding the right professionals to help you, somebody who has the expertise, obviously like the attorneys that we have on this call, Doug, Todd, somebody that has the expertise, knows what they're doing, is familiar with the space. I think all of those things are very important. So, it's 1 o'clock. I'd like to thank our entire panel, Jen, Todd, Doug, and Skip, for the presentation today. And thanks to everyone else for attending. As always, we encourage all of you to let us know your feedback about this program. You will be receiving a SurveyMonkey link that will pop up on your screen at the end of this session. And if you have any questions, the bios are on the website. Feel free to reach out to any of the panelists. So we appreciate your time. Thank you, everyone.
Thank you.
Thank you.
Have a great day.
Have a great day.
Take care.
Bye now.